Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute legal, financial, or psychological advice. Divorce laws vary significantly by state and individual circumstances, and the outcomes discussed are based on historical trends and case studies, rather than an assurance of specific results. We strongly advise all viewers to conduct their own due diligence and consult with a licensed attorney, a certified financial planner, or a qualified mental health professional before making any decisions regarding their personal or legal affairs. This discourse is intended to provide a high-level academic overview of the systemic challenges and strategic frameworks relevant to men navigating the dissolution of marriage in the United States. Statistically, a man in the United States today is more likely to face the dissolution of his household and the redistribution of his life's work than he is to experience any other major financial or legal catastrophe combined. In the American legal system, divorce is not merely a social transition. It is a high-stakes litigation process where the default settings of the court often clash with the modern reality of the male experience. For decades, the narrative surrounding divorce has been simplified into binary tropes of winners and losers, but the academic data suggests a much more complex and often more harrowing reality for men. We are currently witnessing a period where nearly 80% of divorces are initiated by women, according to data from the American Sociological Association. This statistic is not just a number. It is an entry point into a systemic shift that leaves many men reacting to a process they never anticipated, in a form that was built on 1950s social archetypes. The loop we are opening today is simple but profound. Why do so many men enter the divorce process with a sense of logic and fairness, only to exit it with their assets liquidated, their parental rights marginalized, and their mental health in a state of total collapse? It is not necessarily because they were wrong in their conduct, but because they misunderstood the operating system of the family court. This video is the first part of a deep dive masterclass designed to deconstruct that system. We are going to move past the surface-level advice of just getting a good lawyer and instead look at the historical trends, the statutory frameworks, and the behavioral economics that dictate who survives a divorce and who is financially and emotionally decimated by it. The problem we are solving for you today is the information asymmetry that exists the moment a petition for dissolution is filed. Most men spend their lives building a career, a home, and a legacy under the assumption that the legal system will protect their contributions if things go south. However, historical trends in community property and equitable distribution states show that the court's primary function is not to reward contribution, but to ensure post-divorce parity, often at the expense of the higher-earning spouse. By the end of this series, you will understand the specific mechanics of the U.S. legal system that affect men, from the intricacies of the best interests of the child standard to the aggressive calculation of alimony and child support. We are providing you with a roadmap to navigate these potential outcomes with a level of strategic clarity that the average litigant simply does not possess. To understand the current state of divorce for men, we must first look at the historical evolution of the American family court. For most of the 20th century, the legal standard was the tender years doctrine. This was a judicial presumption that during a child's early years, the mother was the naturally superior caregiver. While this doctrine has been officially replaced in almost every state by the best interests of the child standard, academic discourse frequently points to a lingering implicit bias that continues to influence custody arrangements today. Even in a supposedly gender-neutral legal environment, historical trends suggest that men often have to work twice as hard to prove their competency as primary or even equal parents. This is not just a matter of opinion. It is reflected in the high percentage of cases where mothers are still granted primary physical custody, leaving fathers as every other weekend visitors. This masterclass will examine the financial infrastructure of divorce, specifically focusing on the difference between equitable distribution and community property. In states like California or Texas, community property laws dictate a 50-50 split of all assets acquired during the marriage, regardless of who earned the money. In equitable distribution states, the split is supposed to be fair, which the court often interprets as a way to balance the future earning potential of both parties. If you are the higher-earning male, the court may view your future income as a marital asset to be tapped into via alimony, also known as spousal support. We will analyze case studies where men who built successful businesses during their marriage found themselves in a position where they had to buy out their spouse's interest in the company or worse, sell the business entirely to satisfy a court-ordered settlement. Furthermore, we must address the psychological barrier that prevents many men from effectively participating in their own legal defense. There is a documented phenomenon in clinical psychology where men, when faced with the shock of a divorce filing, enter a state of freeze or withdrawal. They often defer to their spouse's demands early in the process out of a sense of guilt, a desire to be a gentleman, or a hope for reconciliation. However, the legal system moves on a timeline that does not wait for emotional processing. Decisions made in the first 90 days of a divorce, such as moving out of the family home or agreeing to a temporary custody schedule, can create a status quo that the court is extremely hesitant to change later. We will explore how to identify these tactical traps and why maintaining your position in the family home and your involvement in daily parenting tasks is critical for your long-term legal standing. The academic discourse on this topic also requires us to look at the intersection of divorce and the American tax code. The Tax Cuts and Jobs Act of 2017 significantly changed the way alimony is treated, making it no longer tax-deductible for the payer and not taxable income for the recipient for any divorce finalized after December 31, 2018. This change has had a profound impact on the net cost of divorce for men, as they are now paying alimony with after-tax dollars, effectively increasing the financial burden of these payments by 30 to 40% in some tax brackets. We will provide detailed breakdowns of how these changes affect your long-term wealth accumulation and why your financial strategy must be adjusted to account for these federal mandates. Finally, we will touch upon the reality of the domestic litigation industry. Divorce is a multi-billion-dollar business in the United States. The longer a case is litigated, the more the legal professionals earn. For a man, the goal is often to reach a resolution and move on with his life, but the system is incentivized to foster conflict. We will discuss the potential outcomes of mediation versus litigation, and why a man's best defense is often a proactive, data-driven offense. This is not about being aggressive for the sake of it. It is about understanding that in a courtroom, the person with the best organized facts and the clearest understanding of the statutory framework usually prevails. This part 1 has been the foundation. As we move into the subsequent sections, we will dismantle the myths, provide the data, and give you the intellectual tools needed to handle one of the most difficult transitions a man can ever face in the United States. The immediate aftermath of a divorce filing is often referred to by legal professionals as the critical window. This period, usually spanning the first 72 hours to the first 30 days, is where the trajectory of the entire case is often set, frequently without the man even realizing it. Historical trends in U.S. family law indicate that the initial moves made during this high-stress phase carry a disproportionate amount of weight in the final judgment. To understand why, we must look at the judicial preference for the status quo. Family court judges are tasked with making life-altering decisions based on limited information. Their default strategy for minimizing harm, particularly to children, is to maintain the current living and financial situation. If you allow a disadvantageous status quo to settle, you are essentially fighting an uphill battle against the court's own desire for stability. Imagine if you are Christopher, a software engineer living in Seattle in 2026. Christopher is served with divorce papers on a Tuesday afternoon. His immediate emotional response is a mix of shock and a desire to de-escalate the situation. To give his spouse space and avoid conflict in front of their 2 children, Christopher packs a bag and stays at a local hotel. He believes he is being the bigger person and protecting his children from a toxic environment. However, from a technical legal perspective, Christopher has just walked into the move-out trap. By voluntarily leaving the marital home, Christopher has signaled to the court that his spouse is the primary caretaker and that he is comfortable with the secondary role. When his attorney later files for 50-50 custody, the opposing counsel will use historical trends in status quo litigation to argue that the children have already adjusted to Christopher's absence and that changing the schedule would be disruptive to their well-being. The move-out trap is not just about physical location. It is about the surrender of the domestic sphere. Step by step, Christopher's decision leads to a series of cascading potential outcomes. First, he loses daily access to his children, which weakens his standing in a best interests of the child evaluation. Second, he loses control over the physical evidence of his life, financial documents, tax records, and hard drives that may be located in the home office. Third, he becomes financially responsible for 2 households. Even though he is living in a hotel or a small apartment, the court will likely expect him to continue paying the mortgage, utilities, and insurance on the family home to maintain the lifestyle of his children and spouse. This creates an immediate liquidity crisis that can prevent a man from hiring the high-level legal representation he needs to contest a complex case. Academic discourse on this subject highlights a concept known as the silver bullet strategy. While this is a sensitive area, case studies show that in high-conflict divorces, one party may use allegations of misconduct or domestic instability to secure an immediate ex parte restraining order. In 2026, the threshold for these temporary orders remains relatively low in many jurisdictions because the court prefers to err on the side of caution. If a man has already moved out, he is in a much weaker position to defend against such claims. Conversely, if he remains in the home, he can document his daily interactions and demonstrate a consistent, peaceful presence. For men in this position, the recommendation from a strategic standpoint is often to remain in the residence, unless there is a legitimate threat of physical harm or a court order mandates removal. Next, we must analyze the financial discovery process, which is the investigative phase of a divorce. Imagine if you are Mark, a small business owner in North Carolina. Mark has spent the last decade building a landscaping company. In his mind, the business is his individual achievement. However, under the principles of equitable distribution, any increase in the value of that business during the marriage may be considered a marital asset. During discovery, Mark will be required to produce every invoice, bank statement, and tax return related to that business. If Mark has been lax with his record keeping, or if he has commingled personal and business expenses, a common occurrence in small enterprises, the court may appoint a forensic accountant. The potential outcome here is a valuation of the business that far exceeds its actual liquid worth, leading to a settlement where Mark must pay his spouse half of a theoretical value he cannot actually access. Step by step, the discovery process involves several key components: interrogatories, which are written questions that must be answered under oath; requests for production, which require the delivery of physical or digital documents; and depositions, where a party is questioned by the opposing attorney in front of a court reporter. For men, the goal of discovery is often defensive, to prove that certain assets are separate property or to debunk inflated claims of lifestyle expenses. Historical trends show that men who are disorganized during this phase face significant financial penalties. The court may draw negative inferences from missing documents, leading to a lopsided distribution of assets. We also need to address the behavioral economics of temporary support orders, or pendente light orders. These are the financial arrangements put in place while the divorce is being litigated. In many U.S. jurisdictions, these orders are calculated using standardized formulas that take a snapshot of the current income and expenses. Imagine if Anthony, a middle manager in Illinois, agrees to a temporary support amount that is at the very top of his budget, thinking it is only for a few months. As the litigation drags on through 2026, that temporary order stays in place. When the case finally reaches a trial or a final settlement, the judge looks at the last 18 months. If Anthony has successfully made those payments, the judge will often use that as evidence that the amount is fair and sustainable. This is the danger of the temporary becoming permanent. Case studies suggest that men who do not aggressively contest inflated temporary support figures often find themselves locked into those numbers in the final decree. Furthermore, let us consider the psychological concept of the high-conflict personality in the context of legal strategy. In academic circles, it is recognized that some litigants view the divorce process as a zero-sum game where the goal is total destruction of the other party. For a man facing this type of opposition, the standard advice of being cooperative can be catastrophic. The legal system is designed to facilitate settlement, but it assumes both parties are acting rationally. When one party is not, the rational party's attempts at compromise are often viewed as a sign of weakness to be exploited. We see this frequently in custody battles where one parent attempts to marginalize the other's role through a series of minor, incremental gatekeeping behaviors, canceling visits, withholding school information, or making unilateral medical decisions. To combat this, a man must move from a reactive posture to a proactive one. This involves meticulous documentation of every interaction. In 2026, this means utilizing parenting apps that are admissible in court, maintaining a detailed log of all parenting time, and ensuring that all financial transactions are transparent and traceable. This data-driven approach removes the emotional variability that judges often find frustrating. Instead of saying his spouse is being difficult, a man can present a spreadsheet showing that 25% of his scheduled parenting time was interfered with over a 6-month period. This level of granular detail is what wins cases in the modern American legal system. As we conclude this part of the discourse, we have established the importance of the status quo, the dangers of the move-out trap, the rigors of the discovery process, and the tactical weight of temporary orders. But what happens when the fight moves from the home to the ledger? In the next part, we are going to dive deep into the world of asset protection and the complex mathematics of alimony. We will explore how the court views retirement accounts, the hidden traps of the 401k QDRO process, and the specific strategies used to protect premarital wealth from being classified as a marital asset. The financial war is just beginning, and understanding the rules of engagement is the only way to ensure there is a legacy left to protect. How does a man protect a business he spent 20 years building when the law says it belongs to two people? We will break down the valuation models and the buyout structures that can save a career from the wreckage of a marriage. The transition from the domestic battlefield to the financial ledger is where the true long-term consequences of a U.S. divorce are solidified. In the eyes of the family court, a marriage is increasingly viewed as a commercial partnership, and the dissolution of that partnership requires a rigorous accounting of every asset acquired, every dollar earned, and every debt incurred from the date of the marriage ceremony until the legal date of separation. To navigate this, a man must understand the fundamental distinction between marital property and separate property, a distinction that is often much more fragile than it appears on the surface. While separate property generally includes assets owned before the marriage or received as a gift or inheritance during the marriage, these assets are subject to a process known as transmutation. Imagine if you are David, a 45-year-old architect living in Chicago in 2026. Before David married in 2016, he owned a townhome worth $500,000. He naturally assumed this was his separate property and therefore untouchable. However, over the course of his 10-year marriage, David used his monthly salary to pay down the mortgage. Because his salary is considered a marital asset, he was essentially using marital funds to increase the equity in a separate asset. Furthermore, he and his spouse decided to renovate the kitchen in 2022, using funds from a joint savings account. By 2026, the court may determine that the townhome has been transmuted into a marital asset, or at the very least, that the community is entitled to a reimbursement for the appreciation in value and the marital funds invested. Historical trends in Illinois and many other states suggest that without a strictly maintained separate account and a meticulous paper trail, the separate property defense often collapses under the weight of commingled funds. This leads us to the concept of tracing, a technical process used by forensic accountants to identify the origin of funds. If David wants to protect the premarital portion of his home, he must provide a clear line of evidence that separates the original equity from the marital contributions. This involves a step-by-step reconstruction of bank statements, mortgage payments, and renovation invoices spanning a decade. In the academic discourse of family law, the burden of proof lies entirely with the party claiming the asset is separate. If the documentation is incomplete, the court's default position is usually to classify the asset as marital, leading to a potential outcome where a man loses half of the wealth he built before he even met his spouse. Beyond physical property, we must address the complex mathematics of alimony, or spousal maintenance. Unlike child support, which is often governed by strict state-mandated formulas, alimony is frequently left to the discretion of the judge, based on a variety of statutory factors. These factors include the duration of the marriage, the age and health of both parties, the standard of living established during the marriage, and the relative earning capacity of each spouse. Case studies of high-earning men in 2026 show that the disparity in income is the primary driver of high alimony awards. If a man earns $300,000 a year and his spouse has been out of the workforce for 15 years, the court will likely order a support payment designed to allow the spouse to live a lifestyle reasonably comparable to the one enjoyed during the marriage. However, the financial impact of alimony was fundamentally altered by the Tax Cuts and Jobs Act. For any divorce finalized in 2026, the payer, usually the higher-earning male, cannot deduct alimony payments from his federal income tax, and the recipient does not report it as taxable income. Consider the case of Robert, a surgeon in Florida. If Robert is ordered to pay $5,000 a month in alimony, he must earn roughly $8,000 in gross income to make that payment after his own taxes are deducted. Meanwhile, his ex-spouse receives the full $5,000 tax-free. This creates a massive net wealth transfer that many men fail to account for when negotiating settlements. Historical trends indicate that men who do not factor in this tax reality often find themselves in a position where their post-divorce cost of living exceeds their take-home pay. The next pillar of the financial war is the division of retirement accounts, specifically 401ks, IRAs, and pensions. These are not split by a simple bank transfer. Instead, the court must issue a Qualified Domestic Relations Order, or QDRO. This is a specialized legal instrument that allows for the tax-free transfer of a portion of a retirement account to an alternate payee. Step by step, the QDRO process involves drafting the order to match the specific requirements of the plan administrator, obtaining the judge's signature, and then submitting it for execution. If a QDRO is poorly drafted, it can trigger immediate tax liabilities and early withdrawal penalties. For men with significant retirement savings, it is crucial to ensure that the QDRO accounts for the premarital portion of the account. For example, if a man had $100,000 in his 401k before the marriage, that base amount plus its market growth should be excluded from the marital split. Failing to insist on this calculation can result in the loss of decades of compound interest. Now let us turn to the most complex asset of all, the closely held business. Imagine if you are Michael, who owns a tech consulting firm in Austin, Texas. In 2026, his business is thriving, but his marriage is ending. The court must now place a dollar value on a business that might not even be for sale. There are three primary valuation models used in these cases. The first is the asset-based approach, which simply looks at the value of the company's equipment, real estate, and accounts receivable. This is often the most favorable model for the owner. The second is the market-based approach, which compares the business to similar companies that have recently sold. The third, and most dangerous for men, is the income-based approach, which applies a multiple to the company's annual earnings to determine a present value. The academic debate here centers on the concept of goodwill. Enterprise goodwill is the value associated with the business's reputation, location, and systems, which is generally considered a marital asset. Personal goodwill, however, is the value tied specifically to the individual owner's skills, relationships, and reputation. If Michael is the sole reason clients hire the firm, a significant portion of the business's value is personal goodwill. In many U.S. jurisdictions, personal goodwill is excluded from the marital estate because it cannot be sold or transferred. However, case studies show that opposing experts will fight to categorize as much value as possible as enterprise goodwill to increase the spouse's payout. A man in this position must be prepared to prove that the business cannot function without his specific, personal involvement. Once a value is established, the question becomes how to pay out the spouse's share without destroying the company. Potential outcomes often involve a buyout structure. Michael might agree to give his spouse a larger share of the equity in the marital home, or a greater portion of the liquid savings accounts in exchange for keeping 100% ownership of his business. This is known as an offset. Alternatively, he might be required to pay the spouse her share over a period of several years, effectively turning the divorce settlement into a long-term debt obligation for the business. As we wrap up this deep dive into the financial structures, we have seen how premarital homes can be lost to transmutation, how alimony is a post-tax burden, and how businesses are valued through the lens of goodwill. But the financial cost of divorce is often dwarfed by the emotional and strategic cost of the custody battle. What happens when the dispute moves from the bank account to the children's bedrooms? In the next part, we will analyze the tactical maneuvers used in custody litigation, the reality of the 50-50 presumption, and the specific ways the legal system evaluates a man's fitness as a father. We will look at how a single text message or a misunderstood social media post can change a custody trajectory in an instant. The fight for your assets is a struggle for your past, but the fight for your children is a struggle for your future. How do you prove your value as a parent to a judge who only sees you for 15 minutes? We are moving into the most high-stakes territory of all. The legal determination of child custody is perhaps the most misunderstood and emotionally volatile aspect of the American matrimonial system. In 2026, the guiding principle across all 50 states remains the best interests of the child standard. While this sounds inherently fair, it is an intentionally broad and subjective framework that grants individual judges immense discretionary power. To navigate this, a man must understand that the court is not looking for a perfect father, but for a stable, consistent, and proactive caregiver who can demonstrate a historical trend of involvement. The court views the child's life through a lens of continuity, meaning that the parent who can best prove they have been the primary engine of the child's daily routine often holds the strategic advantage. Consider the case of Ethan, a project manager in Florida in 2026. Under Florida's recent legislative shifts, there is now a statutory presumption that equal time sharing or a 50-50 split is in the best interest of the child. However, Ethan's spouse is contesting this, arguing that Ethan's 45-hour work week and frequent business travel make him an intermittent parent. This is a common hurdle for men in the U.S. legal system. The court does not necessarily penalize a man for working, but it does scrutinize the logistics of how that work interferes with parenting. Ethan's potential outcome depends on his ability to present a granular, data-driven parenting plan that accounts for every hour of the child's day, rather than relying on the vague hope that the judge will simply split the time down the middle. A comprehensive parenting plan in 2026 is a multi-page document that functions as the operating manual for the child's upbringing. Step by step, Ethan must define not just the weekly schedule, but the exact locations for exchanges, the protocol for holiday rotations, and the specific parameters of legal custody. Legal custody, distinct from physical time-sharing, refers to the right to make major decisions regarding education, healthcare, and religious upbringing. Historical trends show that many men focus so heavily on the calendar that they inadvertently surrender joint legal custody, leaving them with no say in which school their child attends or what medical treatments they receive. To succeed in a contested custody battle, a man must be prepared for the involvement of a guardian ad litem or a court-appointed custody evaluator. These professionals serve as the eyes and ears of the court. Imagine if an evaluator is assigned to Ethan's case. They will conduct home visits, interview teachers, and observe the interaction between Ethan and his children. In academic discourse, this is known as a social study. For a man, the home visit is a high-stakes event. The evaluator is not looking for a mansion. They are looking for a dedicated space for the child, proof of age-appropriate toys and books, and evidence that the father knows the child's specific needs, such as their favorite meal, their allergies, or the names of their best friends. Case studies indicate that men who fail to prepare for these interviews by being unable to recall the names of the children's doctors or teachers are often categorized as secondary parents, regardless of their financial contributions. The digital landscape of 2026 has introduced a new layer of complexity to custody litigation: the permanent digital footprint. Every text message, email, and social media post is potentially admissible in court. Historical trends in family law suggest that high-conflict cases are often decided not by what happens in the courtroom, but by what was sent in a moment of anger via a smartphone. If Ethan sends an aggressive text message to his spouse at 2 a.m, that single piece of evidence can be used to argue that he lacks the emotional regulation necessary for primary or equal custody. Modern legal strategies for men now prioritize the use of court-monitored communication apps. These platforms create a transparent, uneditable record of all interactions. By moving all communication to such a platform, Ethan can insulate himself from false allegations and demonstrate a consistent, business-like tone in all co-parenting matters. Furthermore, we must analyze the concept of the right of first refusal. This is a common clause in U.S. parenting plans stating that if one parent is unavailable for a certain period, usually 4 to 8 hours, they must offer the other parent the opportunity to care for the child before calling a babysitter. While this sounds equitable, it can be used as a tool for surveillance and control in high-conflict divorces. If Ethan has a late meeting, and his spouse uses the right of first refusal to constantly interrupt his parenting time, it can undermine his ability to establish a stable routine. We will examine how to structure these clauses with specific time thresholds and notification requirements to ensure they support the child's stability, rather than becoming a source of ongoing litigation. Another critical factor in 2026 is the role of the vocational expert. If a spouse claims they cannot work and therefore must have primary custody while the man works and pays support, the man's legal team may request a vocational evaluation. This involves a professional assessing the spouse's education, work history, and current market conditions to determine their earning capacity. The potential outcome is the court imputing income to the spouse, meaning the court treats them as if they are earning a certain amount, even if they are not. This shifts the financial dynamic and can influence the custody schedule by proving that both parents are equally capable of balancing professional and parental responsibilities. We also need to discuss the reality of parental alienation, a controversial but frequently cited concept in academic and legal circles. This refers to a situation where one parent systematically undermines the child's relationship with the other parent. Case studies from various U.S. jurisdictions show that courts are becoming more sensitive to these patterns, but the burden of proof is exceptionally high. A man cannot simply claim alienation. He must document the specific behaviors, such as the other parent withholding phone calls, making derogatory comments in front of the child, or creating loyalty binds, where the child feels they must choose sides. In 2026, proving these patterns often requires the testimony of a child psychologist or a forensic therapist who can identify the behavioral markers in the child. As we move through this masterclass, it becomes clear that the custody battle is won in the margins. It is won through the meticulous documentation of every soccer practice attended, every dental appointment scheduled, and every night spent reading bedtime stories. It is won by maintaining a calm, stoic presence in the face of provocation. The court is looking for the parent who can most effectively shield the child from the conflict of the divorce. If you become a source of conflict, you lose your standing. The struggle for custody is deeply intertwined with the financial structures we discussed previously. In many states, the amount of child support a man pays is directly tied to the number of overnights he has with his children. This creates a perverse incentive for parties to fight for time not out of love, but out of a desire to increase or decrease a monthly payment. In the next part of this series, we are going to dive into the cold, hard mathematics of child support. We will break down the income shares model used in the majority of U.S. states, the hidden costs of health insurance and extracurricular activities, and the specific ways that the 2026 economy is changing how courts calculate the cost of raising a child. What happens when your income fluctuates? How does the court handle a bonus or a stock option? We will unravel the formulas that will dictate your financial life for the next decade. To navigate the financial landscape of 2026, one must accept that child support in the United States is no longer a matter of judicial intuition or a simple handshake agreement. It has evolved into a highly algorithmic process, primarily governed by the income shares model, which is currently utilized in approximately 40 states. The underlying philosophy of this model is that a child should receive the same proportion of parental income that they would have received if the parents were still living in the same household. However, for a man, the application of this formula often feels less like an equitable distribution and more like a permanent tax on his future productivity. To understand the potential outcomes, we must break down the specific mechanics of how the court arrives at a number that will dictate your lifestyle for the next decade. Imagine if you are Jason, a systems analyst in Ohio in 2026. Jason earns $140,000 a year, while his spouse earns $60,000. Under the income shares model, the court first determines the combined adjusted gross income of the parties. Step by step, the court takes Jason's $140,000 and subtracts specific allowable deductions, such as taxes, mandatory retirement contributions, and perhaps support for children from a previous relationship. Once the combined income is established, in this case $200,000, the court looks at a state-mandated table to find the basic support obligation. This table is based on economic data regarding the actual cost of raising a child in a specific state. If the table says it costs $3,000 a month to raise 2 children at that income level, Jason is responsible for 70% of that amount, or $2,100, because he provides 70% of the total income. However, the calculation does not end there. In 2026, the most significant variable in child support is the parenting time adjustment, often referred to as the overnights multiplier. Historical trends show that many states have adopted a cliff, or a sliding scale, where the amount of support drops significantly once a father crosses a certain threshold of overnights. For example, in many jurisdictions, if a father has 128 or more overnights per year, he is considered to have shared physical custody. This triggers a different formula that accounts for the fact that Jason is directly providing food, shelter, and clothing during his time with the children. Imagine if Jason has 127 overnights. He pays the full $2,100. If he secures just one more overnight to reach 128, his support obligation could drop by hundreds of dollars a month. This creates a high-stakes environment where custody battles are often proxy wars for financial survival. But what happens when your income is not a steady biweekly paycheck? In the modern economy of 2026, many men receive a significant portion of their compensation through bonuses, commissions, or restricted stock units, known as RSUs. Consider the case of Marcus, a vice president of sales in Georgia. Marcus has a base salary of $150,000, but his annual performance bonus can range from $50,000 to $200,000. Historically, courts have struggled with this volatility. In 2026, a common potential outcome is the use of a Smith-Ostler or a bonus order. This is a supplemental order where Marcus pays a fixed percentage of his base salary as base child support, and then a separate, predetermined percentage of any gross bonus he receives. This ensures the children benefit from his success, But it also means Marcus never truly knows his total annual liability until the end of the fiscal year. The tech sector presents even more complex challenges regarding RSUs and stock options. Imagine if you are Kevin, a software engineer in San Jose. A large part of Kevin's wealth is tied to RSUs that vest over 4 years. In 2026, the California courts and many others treat vested RSUs as income for the purposes of calculating child support. This can create a liquidity crisis. If Kevin's stock vests during a market downturn, he may be taxed on the value at the time of vesting, while the court uses that same high value to calculate a support payment he must pay in cash. If the stock price then drops before he can sell, he is left paying support based on phantom income he no longer possesses. Case studies indicate that men in these positions must advocate for a flexible support order that allows for adjustments based on the actual realized value of the stock, rather than the theoretical value at the moment of vesting. We must also address the hidden costs of child support, often referred to as add-ons or Section 7 expenses. These include health insurance premiums, work-related childcare, and extraordinary medical expenses. In 2026, these are typically split pro rata based on income. If Jason earns 70% of the income, he pays 70% of the $500 a month health insurance premium. Furthermore, the court may order a split for extracurricular activities. Imagine if Jason's spouse enrolls their daughter in elite travel soccer, which costs $10,000 a year. If the court deems this an agreed-upon or necessary expense, Jason could be responsible for $7,000 of that cost on top of his monthly support. Historical trends show that men who do not include specific language in their decree, requiring mutual consent for high-cost activities, often find themselves blindsided by these additional financial demands. Another critical area of academic discourse is the concept of imputed income. This occurs when the court determines that a man is intentionally underemployed to avoid his support obligations. Imagine if Anthony, a corporate lawyer earning $250,000, decides to quit his high-stress job in 2026 to become a freelance writer earning $40,000. His spouse will likely argue that Anthony is shirking his duties. The court may then hire a vocational expert to testify about Anthony's earning capacity. The potential outcome is that the court will calculate child support based on Anthony's ability to earn $250,000, regardless of what he is actually making. This can lead to a situation where the support payment is actually higher than the man's total take-home pay, forcing him into a cycle of debt or legal contempt. The danger of the modification trap cannot be overstated. Child support is never truly final. It can be modified whenever there is a substantial change in circumstances, such as a job loss, a significant raise, or a change in the child's needs. However, the most important rule in 2026 remains the prohibition against retroactive modification. If Jason loses his job in June but waits until December to file a motion to reduce his support, the court generally cannot forgive the arrears that accumulated during those 6 months. Even if he was unemployed and had zero income, the law views those unpaid months as a judgment that must be paid. Historical trends show that thousands of men fall into a hole of permanent debt because they did not understand that the support clock only stops when the court says it stops. As we conclude this analysis of the financial mechanics of support, we see a system that is designed for efficiency and predictability, but one that often fails to account for the nuance of a man's professional life. We have moved from the broad strokes of custody to the granular detail of the income shares model and the complexities of variable compensation. But even with the math settled, the most daunting phase of the divorce process remains. What happens when negotiations fail, and you find yourself standing before a judge in a formal trial? In the next part, we are going to go inside the courtroom. We will break down the rules of evidence, the art of the deposition, and how to testify under cross-examination without destroying your own case. We will explore how to manage the optics of your life when a stranger in a black robe is deciding your future. The trial is the ultimate test of your preparation, and we will show you how the most successful litigants maintain their composure when everything is on the line. How do you handle a hostile witness who is telling a different version of your own life? We are going into the mechanics of the trial. The trial is not a search for absolute truth. It is a search for admissible evidence that fits a specific legal theory. In the American family court system of 2026, the trial is the final stage of a long and expensive process where the narrative of your life is condensed into exhibits and testimony. For a man, the The trial is often a defensive maneuver against a characterization that may be decades in the making. To succeed, you must understand that the judge is not looking at who you are as a human being, but rather at how well your presentation aligns with the statutory requirements of the state. Imagine if you are Stephen, a chief technology officer for a mid-sized firm in New York City in 2026. Stephen is facing a high-stakes trial involving both a complex property division and a contested custody arrangement for his 3 children. His spouse's legal team has built a narrative that Stephen is a workaholic who has been emotionally absent for a decade. In this scenario, Stephen's greatest asset is not his emotional plea, but his ability to use the rules of evidence to dismantle that narrative piece by piece. Historical trends in family law indicate that the trial is won or lost long before the first witness is called. This is done through the deposition. A deposition is a formal, out-of-court session where a witness provides testimony under oath, which is then transcribed. Step by step, the goal of a deposition is to lock the other party into a specific story. If Stephen's spouse testifies in a deposition that he never attended a single parent-teacher conference, but Stephen has emails from the school and calendar invites showing his attendance, he has just created a path for impeachment. Impeachment by prior inconsistent statement is one of the most powerful tools in a trial. When the spouse repeats that claim on the witness stand, Stephen's attorney can present the deposition transcript and the physical evidence, effectively destroying the witness's credibility in the eyes of the judge. Once the trial begins, we move into the phase of direct examination. This is when your own attorney asks you questions to tell your story. Historical trends suggest that men often struggle here because they want to argue their case, rather than provide facts. In 2026, the successful litigant follows the rule of the 5 Ws. Who, what, where, when, and why. Your testimony should be a series of objective observations. Instead of saying, "I am a great father," Stephen should testify, "Every Tuesday and Thursday in 2025 and 2026, I picked the children up from soccer practice at 4 o'clock and prepared dinner by 6 o'clock. This shifts the focus from subjective opinion to verifiable fact. The most dangerous part of the trial for any man is cross-examination. This is when the opposing attorney asks questions designed to provoke an emotional response or lead you into a trap. These are almost exclusively leading questions, which are questions that suggest their own answer and only require a yes or no. Imagine the opposing attorney asking Stephen, "You prioritize your quarterly board meetings over your daughter's gymnastics meets, don't you?" The natural instinct is to explain or get angry. However, case studies of successful litigants show that the best strategy is the one-word answer. Yes, no, or I do not recall. By refusing to provide the emotional fuel the opposing attorney needs, Stephen maintains his composure and prevents the creation of a negative soundbite for the court record. In the 2026 legal landscape, the rules of evidence regarding digital data have become incredibly sophisticated. We are seeing a move toward the mandatory authentication of all social media and messaging data. This means that a screenshot of a text message is no longer enough. You may need the metadata or a forensic export to prove the message was not altered. Step by step, if you intend to use a text message to prove a point, you must lay a foundation. This involves testifying that you recognize the phone number, that the conversation took place on a specific date, and that the exhibit is a fair and accurate representation of that conversation. Men who fail to properly authenticate their digital evidence often find their most powerful smoking gun excluded from the trial entirely. We must also address the role of the hostile witness. This could be a mother-in-law, a neighbor, or even a former friend who provides a different version of your life. Handling these witnesses requires a clinical approach. You do not win by arguing with them. You win by showing they lack the foundation for their testimony. If a neighbor testifies that Stephen was never home, his attorney will cross-examine that neighbor on how many hours a day they actually spend observing Stephen's front door. By exposing the witness's lack of personal knowledge, the testimony is rendered useless. Potential outcomes in these scenarios usually involve the judge giving very little weight to the testimony of biased third parties, focusing instead on the cold, hard data of bank statements and school records. Another critical component of the 2026 trial is the use of expert witnesses. In complex financial cases, a business valuator or a forensic accountant will testify. In custody cases, it might be a child psychologist. Academic discourse on this subject highlights the concept of Daubert challenges. This is a legal maneuver used to exclude an expert's testimony if their methodology is not scientifically sound or peer-reviewed. If the opposing side's custody evaluator used an outdated psychological test or a biased interview process, Stephen's attorney can move to have that expert's entire report thrown out. This is why having your own rebuttal expert is a historical trend in successful high-net-worth divorces. As the trial concludes, the attorneys provide closing arguments. This is where they weave the testimony and the exhibits into a final narrative that fits the law. The judge will not make a decision immediately. In 2026, most family court judges take the case under advisement, meaning they will review the evidence and issue a written ruling weeks or even months later. This period of waiting is often the most stressful part of the entire process for men. The trial is a grueling experience that tests your financial resources and your mental health. But it is also the place where the truth, or at least the admissible version of it, is finally put on the record. We have deconstructed the mechanics of the courtroom, from the tactical use of depositions to the high-pressure environment of cross-examination. We have seen how digital evidence must be authenticated and how experts can be challenged. But what happens once the judge finally signs the decree? Is the battle truly over? Or does it simply change shape? In the next part, we are going to explore the post-decree landscape. We will analyze the world of enforcement, the reality of parental alienation after the trial, and the specific legal steps required to modify an order when life inevitably changes. We will also discuss the concept of the divorce hangover and how to begin the process of rebuilding your identity and your legacy in a post-marriage world. What do you do when the other party refuses to follow the court's order? How do you protect your rights without ending up back in a courtroom every 6 months? We are moving into the long-term strategy for your new life. The finality of a judicial signature on a divorce decree is often mistaken for the end of the conflict. But in the academic study of American domestic relations, the post-decree phase is where the theoretical rights established in court meet the friction of real-world application. In 2026, a man who has successfully navigated the trial must transition from a litigious mindset to an administrative and protective mindset. A court order is not self-executing. It is merely a set of instructions that requires active monitoring and, in many cases, aggressive enforcement. Historical trends suggest that the period immediately following the entry of a final judgment is when the risk of non-compliance is highest, as the emotional exhaustion of the process often leads men to lower their guard, just as the new status quo is being tested. To understand the mechanics of enforcement, imagine the case of Brandon, a marketing executive in Denver in 2026. Brandon's final decree awarded him 50-50 parenting time and required his ex-spouse to refinance the marital home to remove his name from the mortgage within 90 days. However, 60 days in, his ex-spouse begins a pattern of marginal interference. She claims the children have soccer tournaments during his scheduled weekends, or that they are too tired for the Wednesday night visit. Simultaneously, she informs him that her credit score is insufficient for the refinance, leaving Brandon's debt-to-income ratio skewed and preventing him from securing a loan for his own residence. In this scenario, Brandon is facing a dual threat to his post-divorce stability. Step by step, his first recourse is the filing of a motion for contempt or an order to show cause. In the U.S. legal system, contempt is the mechanism by which a judge punishes a party for willfully violating a court order. For the parenting time interference, Brandon must provide a clear evidentiary trail. Historical trends in 2026 show that judges are increasingly intolerant of gatekeeping behaviors, but they require objective proof. Brandon's use of a court-mandated communication app, which timestamps his arrival for exchanges and logs the denials of access, becomes his primary weapon. Potential outcomes for this type of contempt include make-up parenting time, the payment of Brandon's attorney fees, and in persistent cases, a modification of the custody schedule to favor the parent who is more likely to facilitate a relationship with the other. Regarding the financial non-compliance, Brandon's situation highlights the limitation of family court power over third-party lenders. The judge can order a spouse to refinance, but the judge cannot force a bank to lend money. If Brandon's ex-spouse cannot qualify for a loan, Brandon's legal team must return to court to request an alternate remedy, such as the immediate listing of the home for sale. This is a common post-decree hurdle for men. The academic discourse on this topic emphasizes the need for self-executing language in the original decree, stating, for example, that if the refinance is not completed by day 90, the house is automatically placed on the market with a specific broker. Without this language, Brandon is forced into a new round of litigation just to move on with his financial life. Beyond enforcement, we must address the psychological and legal phenomenon of the slow fade in parental alienation. Unlike the overt interference Brandon experienced, The slow fade is a systematic process where a child is subtly encouraged to view the father as an optional or secondary figure in their life. In 2026, this often manifests through the digital exclusion of the father from school portals, medical updates, and extracurricular group chats. Academic research into fatherhood post-divorce indicates that men who are excluded from these information loops often experience a sense of disenfranchisement, which leads to a voluntary withdrawal over time. To combat this, a man must exercise his legal custody rights proactively. This means personally contacting the school and medical providers to ensure his contact information is on file as a primary guardian, rather than waiting for the other parent to provide updates. As life progresses into 2026 and beyond, the reality of change necessitates the concept of modification. A divorce decree is based on a snapshot of life at the time of the trial, but the law recognizes that circumstances are not static. The legal standard for changing a court order is a substantial and material change in circumstances that was not contemplated at the time of the original order. Imagine the case of Greg, a civil engineer who 6 months after his divorce, receives a job offer in a different state that would double his salary but require him to move 800 miles away. Greg is now entering the high-stakes world of relocation litigation. In most U.S. jurisdictions in 2026, a parent cannot move a child a significant distance, typically defined as more than 50 or 100 miles, without the consent of the other parent or a court order. The court's analysis in relocation cases is incredibly rigorous. Historical trends show that courts are increasingly skeptical of relocation if it significantly diminishes the other parent's time, regardless of the economic benefit to the relocating parent. If Greg moves alone, he must file for a modification of child support based on his new, higher income, while also negotiating a new long-distance parenting plan that might involve fewer, but longer, blocks of time during summer and school breaks. The financial rebuilding phase for men in 2026 also involves navigating the divorce hangover. This is the period of economic and emotional recovery, where a man must reconstruct his legacy from a depleted asset base. Case studies of men who successfully rebuild their wealth post-divorce show a common trend: a shift toward aggressive diversification and a focus on non-liquid assets that are harder to reach in potential future litigation. This is also the time to address the tax implications of the division of assets. If Greg received a portion of a retirement account via QDRO, he must ensure the funds are rolled over into an IRA within the specified time frame to avoid a massive tax hit. Furthermore, the academic discourse on male resilience post-divorce emphasizes the importance of identity reconstruction. For many men, their identity was tied to their role as a husband and a provider within a nuclear family unit. When that unit is dissolved, there is often a period of profound disorientation. Historical trends in public health data suggest that men who do not actively seek out new social frameworks and professional goals are at a significantly higher risk for long-term clinical depression and career stagnation. In 2026, the strategic man views his mental health and social integration as a critical part of his post-divorce legacy. As we look toward the future, we must also consider the reality of re-entry into the dating and relationship market. For a man who has been through the American family court system, the prospect of a new partner brings both emotional hope and new legal risks. What happens when a new partner begins to spend significant time around your children? How do the courts in 2026 view cohabitation in the context of alimony? The landscape of your new life is beginning to take shape. You have moved from the shock of the filing, through the fire of the trial, and into the complex reality of enforcement and modification. But the story does not end with your recovery. It continues with the evolution of your family. In the next part, we are going to dive into the intricate world of co-parenting with a high-conflict ex-spouse, the legal implications of introducing new partners to your children, and the specific strategies used to protect your rebuilt assets from the risks of a second marriage. We will explore the modern prenuptial agreement in 2026 and why the lessons learned in your first divorce are the most valuable assets you now own. How do you build a new future without repeating the mistakes of the past? We are moving into the strategy of the second act. The transition into the second act of a man's life begins the moment the legal ink dries, but the intellectual and strategic work of rebuilding is often more complex than the dissolution itself. In the United States in 2026, the social and legal landscape for a divorced man is fraught with invisible tripwires that can retroactively affect his financial standing and his relationship with his children. As you begin to navigate new relationships, you must move away from the emotional spontaneity of your youth and toward a framework of risk management and asset preservation. This is not about cynicism. It is about the academic application of lessons learned through the American family court system. One of the most significant financial hazards in the post-divorce phase is the alimony cohabitation trap. Consider the case of Tyler, a 38-year-old financial analyst in New Jersey in 2026. Tyler was ordered to pay $4,000 a month in spousal support for a term of 6 years. 2 years into this term, Tyler notices via social media and neighborhood observation that his ex-spouse's new partner has essentially moved into the former marital home. Tyler assumes that because his ex-spouse is now in a committed, supportive relationship, his obligation to pay alimony should naturally cease. However, historical trends in U.S. family law indicate that proving cohabitation is an evidentiary mountain that most men fail to climb. In 2026, the legal definition of cohabitation has evolved beyond simply sharing a roof. Courts now look for evidence of a mutually supportive relationship that mirrors a marriage. Step by step, Tyler must prove economic interdependence. This involves demonstrating that the new partner is contributing to household expenses, sharing groceries, or perhaps using a joint bank account. It also involves proving the stability of the relationship through shared vacations, social recognition, and the length of the cohabitation. Potential outcomes for Tyler depend entirely on his ability to gather admissible evidence. Case studies show that men who hire private investigators to document the new partner's vehicle at the residence over a consecutive 30-day period, or who subpoena social media records showing a shared life, are far more likely to succeed in a motion to terminate or reduce alimony. Without this granular data, the court will likely maintain the status quo, forcing Tyler to continue subsidizing his ex-spouse's new household. As Tyler enters the dating market himself, he faces the challenge of integrating a new partner into his children's lives. In 2026, many U.S. parenting plans include a morality clause or a paramour clause. These clauses typically state that neither parent may have a romantic partner spend the night while the children are present for a specific duration after the divorce, often 6 to 12 months. Imagine if Tyler meets a new partner and wants her to join him on a weekend trip with his children. If he violates a paramour clause, he is not just breaking a social rule. He is in contempt of court. Historical trends suggest that high-conflict ex-spouses will use these violations as leverage to file for a modification of custody, arguing that the father is introducing instability into the children's lives. The academic discourse on co-parenting in 2026 increasingly emphasizes parallel parenting as a primary strategy for men dealing with high-conflict counterparts. While the court often pushes for a collaborative co-parenting model, this can be a trap for a man who is constantly met with hostility. Parallel parenting is a risk mitigation framework where each parent operates independently during their time with the children. Shutterstock. In a parallel parenting model, communication is strictly limited to an online portal, and there is zero verbal interaction during exchanges. Step by step, this involves removing the opportunity for conflict by ensuring that all details regarding school, health, and extracurriculars are documented in the portal rather than discussed in person. This prevents the he said, she said dynamic that often leads back to a courtroom. Case studies indicate that men who adopt parallel parenting early in their second act report significantly lower stress levels and fewer legal fees, as they are no longer reacting to the emotional provocations of their ex-spouse. Now let us address the most critical part of the second act: protecting your rebuilt legacy through the 2026 prenuptial agreement. If you choose to remarry or even enter a long-term cohabitation arrangement in 2026, you are entering a legal contract by default. In many states, long-term cohabitation can trigger claims of palimony or constructive trusts over assets you worked hard to recover. To prevent a repeat of a catastrophic asset division, a modern prenuptial agreement is essential. Imagine if Nathan, a 50-year-old business owner in California, decides to remarry in late 2026. Nathan has spent the last 3 years rebuilding his consulting firm. He understands that a standard, off-the-shelf prenup is often vulnerable to being overturned on the grounds of unconscionability or lack of full disclosure. A professional academic-grade prenup in 2026 must be airtight. This involves a step-by-step process of full financial disclosure, where every asset, debt, and potential future inheritance is listed in an exhaustive exhibit. Crucially, both parties must be represented by independent legal counsel. If Nathan's new partner uses his attorney or signs the document without a lawyer, a judge in 2035 could easily throw the agreement out, claiming she was under duress or did not understand the terms. Historical trends show that courts are increasingly sensitive to the timing of the signing. A prenup signed 3 days before the wedding is much more likely to be overturned than one signed 3 months before. Nathan's strategy should also include a sunset clause or a lifestyle clause, which provides for specific, predetermined increases in the spouse's settlement over time, ensuring the agreement remains fair in the eyes of a future court, while protecting the core of his business and premarital wealth. We must also consider the role of the Domestic Asset Protection Trust or DAPT. In 2026, more men are utilizing these irrevocable trusts in states like Nevada or South Dakota to hold their assets. ADAPT allows you to be a discretionary beneficiary while protecting the trust assets from future creditors, including a future ex-spouse. Academic research into high net worth protection suggests that combining a DAPT with a robust prenuptial agreement creates a multi-layered defense that is almost impossible to penetrate. However, the second act is not just about defense. It is about the offensive pursuit of a new life. This involves a psychological recalibration. Historical trends in male wellness post-divorce show that men who successfully reintegrate into society are those who view their divorce not as a failure, but as a high-cost tuition for a masterclass in human behavior and legal reality. You are now a more sophisticated actor in the social and economic sphere. You understand the value of documentation, the necessity of emotional stoicism, and the reality of the U.S. legal system. As we conclude this part of our deep dive, you have the tools to manage cohabitation traps, navigate the complexities of new partners, and protect your future through advanced legal instruments. But as your new life takes flight, a new set of challenges emerges on the horizon. What happens when the conflict isn't just with an ex-spouse, but with the federal government? In the next part, we are going to explore the intersection of divorce and the Internal Revenue Service. We will break down the audits that often follow high net worth divorces, the hidden liabilities of joint tax returns from the marriage years, and how to protect yourself from the innocent spouse trap. We will also look at the international landscape. What happens if your ex-spouse attempts to relocate with your children to another country? We are moving into the realm of high-stakes jurisdictional and federal conflict. How do you defend your rights when the battle moves beyond the family court? The answer lies in the complex web of federal and international law. When the conflict expands beyond the walls of the county family court and enters the jurisdiction of federal agencies or international treaties, the level of complexity and risk increases by an order of magnitude. For a man in the United States in 2026, the two most significant external threats are the Internal Revenue Service and the international protocols governing parental rights. These entities do not care about your local divorce decree. They operate under federal mandates and global accords that can override state-level rulings. To protect your interests, you must understand the intersection of tax law and jurisdictional sovereignty. The most common federal trap for men is the concept of joint and several liability. Imagine if you are Jonathan, a senior project manager in Virginia in 2026. During your marriage in 2024 and 2025, you and your spouse filed joint federal income tax returns. Your divorce decree, signed in early 2026, explicitly states that your ex-spouse is responsible for any tax liabilities arising from her failed boutique business. However, the IRS is not a party to your divorce. If an audit later reveals that your ex-spouse underreported income or claimed fraudulent deductions during those years, the IRS will pursue both of you for the full amount of the back taxes, interest, and penalties. Historical trends show that the IRS will often target the spouse with the higher income or more liquid assets, frequently the man, because he is the easier source for collection. To defend against this, you must analyze the mechanics of innocent spouse relief under IRS Code Section 6015. Step by step, if Jonathan finds himself facing a massive tax bill for his ex-spouse's errors, he must file Form 8857. There are 3 potential outcomes here. First is traditional innocent spouse relief, where Jonathan must prove that at the time he signed the joint return, he did not know, and had no reason to know, that there was an understatement of tax. Second is the separation of liability, which allocates the tax deficiency between the two spouses based on their individual income and deductions. The third is equitable relief, which is a catch-all for situations where it would be unfair to hold the man liable given all the facts and circumstances, such as being misled or facing domestic interference in financial matters. Case studies indicate that men who failed to file for this relief within the 2-year window of the IRS's first collection activity often lose their right to contest the debt entirely. Furthermore, we must address the specific audit triggers inherent in high net worth divorces. In 2026, the IRS utilizes sophisticated algorithms to flag inconsistent asset valuations. If you value your business at $2 million for the purpose of the marital property split, but your tax returns show minimal profits and low valuation, you are effectively inviting a federal audit. Academic discourse on this topic emphasizes the need for tax-sensitive valuation. This means ensuring that your forensic accountants are not just looking at the divorce court, but also at the potential federal tax consequences of the positions you take. A short-term win in property division can lead to a long-term disaster in federal tax court. The battle takes an even more dramatic turn when it crosses international borders. Imagine the case of Liam, a commercial pilot living in Chicago in 2026. Liam has joint custody of his 5-year-old son. His ex-spouse, a dual citizen of the United States and the United Kingdom, decides to take the child to London for a summer vacation, but then refuses to return, claiming the child is now settled in a British school. This is not a matter for the Chicago police. This is a high-stakes international legal conflict, governed by the Hague Convention on the Civil Aspects of International Child Abduction. Step by step, Liam's defense begins with the immediate filing of a Hague petition in the central authority of the United States or directly in the foreign court. The Hague Convention is not about who is the better parent. It is a jurisdictional treaty designed to return the child to their country of habitual residence. To succeed, Liam must prove 3 things. First, that the child was habitually resident in the U.S. immediately before the removal. Second, that the removal was in breach of Liam's rights of custody under Illinois law. And third, that he was actually exercising those rights at the time of the removal. Potential outcomes in Hague cases are often decided on the interpretation of the term habitual residence. In 2026, international courts look at the shared intent of the parents and the child's degree of integration into the social and educational environment. If Liam's ex-spouse can prove that Liam consented to the child living in London, or if she can demonstrate that returning the child would pose a grave risk of physical or psychological harm, the UK court may refuse to send the child back. Case studies show that for men in this position, speed is the most critical factor. Every day the child remains in a foreign country, their habitual residence begins to shift in the eyes of the law. We must also consider the federal protections within the United States that prevent domestic jurisdictional hopping. The Parental Kidnapping Prevention Act and the Uniform Child Custody Jurisdiction and Enforcement Act are the federal and state frameworks that ensure only one state has the power to make custody decisions at any given time. If your ex-spouse moves to another state and attempts to open a new custody case there to get a more favorable ruling, these laws act as a firewall. Historical trends show that men who proactively register their out-of-state orders in their new jurisdiction can prevent the forum shopping that often plagues high-conflict divorces. The financial and legal infrastructure of 2026 also requires an understanding of the Qualified Domestic Relations Order in the context of federal bankruptcy law. While most debts can be discharged in bankruptcy, domestic support obligations, such as child support and alimony, are non-dischargeable. This means that even if a man or his ex-spouse files for Chapter 7 or Chapter 13 bankruptcy, the obligation to pay support remains. However, the division of marital property, such as a buyout payment for a business, may be dischargeable in some specific bankruptcy chapters depending on how the decree is worded. Academic discourse suggests that men should always insist on language in their decree that characterizes property settlements as domestic support obligations to ensure they cannot be wiped out by a spouse's strategic bankruptcy filing. As we move through these high-stakes federal and international layers, it becomes clear that a man's legal strategy must be multidimensional. You are not just fighting a divorce. You are managing a complex portfolio of legal and financial risks that span the IRS, the Department of State, and the federal courts. We have deconstructed the innocent spouse trap, the mechanics of international abduction treaties, and the non-dischargeability of support in bankruptcy. But even with all these technical defenses in place, there is one final, overarching challenge. How do you integrate all these lessons into a coherent life philosophy that allows you to thrive after the dust settles? How do you move from being a litigant to being a leader of your own life again? In the final part of this deep dive masterclass, we are going to synthesize everything we have learned. We will discuss the final verdict on the male experience in the U.S. divorce system, the roadmap for long-term legacy building, and the specific mindset shifts required to ensure that your divorce was not an ending, but a necessary, albeit painful, evolution. We are coming to the conclusion of the discourse. The final part is the blueprint for the rest of your life. The transition from the scorched earth of a concluded divorce to the construction of a permanent, sustainable legacy is the final and most critical phase of this academic discourse. In the United States in 2026, a man who has emerged from the family court system is often likened to a survivor of a natural disaster. The immediate danger has passed, but the infrastructure of his life requires a total redesign. This final blueprint is not about returning to who you were before the filing. It is about utilizing the hard-won data of the last 9 parts to architect a version of yourself that is fundamentally anti-fragile. To achieve this, we must look at the 3 pillars of the post-divorce legacy: the financial fortress, the parental stewardship, and the psychological recalibration. Imagine if you are Marcus, a 52-year-old healthcare executive in Philadelphia in 2026. Marcus has just completed a 2-year litigation process that cost him 40% of his liquid assets and resulted in a significant alimony obligation. However, Marcus does not view this as a defeat. Instead, he views the final decree as a baseline from which he will build his second foundation. Step by step, Marcus begins by auditing his entire estate plan. A common and catastrophic error for men in 2026 is failing to update beneficiary designations immediately following a divorce. Historical trends indicate that billions of dollars in life insurance proceeds and retirement accounts are paid out to ex-spouses every year simply because the decedent forgot to change a form. Marcus proactively updates his 401k, his IRA, and his term life insurance policies, ensuring that his children or a dedicated trust are the named beneficiaries. This is the first brick in his new wall of protection. Next, Marcus addresses the reality of the 2026 economic environment. With shifting tax brackets and the continued impact of the 2017 Tax Cuts and Jobs Act on alimony, Marcus realizes that his traditional investment strategy must change. He moves away from assets that are easily reachable in a potential future domestic dispute and toward more sophisticated vehicles. This involves the academic application of asset protection through the use of an irrevocable life insurance trust or a family-limited partnership. By placing his rebuilt wealth into structures that have a high degree of statutory protection, Marcus is ensuring that his future earnings are insulated from the risks of a second marriage or an aggressive modification attempt by his ex-spouse. Historical trends in high net worth recovery show that men who prioritize asset protection over high-risk growth in the first 5 years post-divorce are significantly more likely to achieve long-term financial independence. Now, let us turn to the pillar of parental stewardship. The academic discourse on fatherhood in 2026 has moved past the concept of the visitor and toward the concept of the primary moral authority. Even if Marcus has a 50-50 custody split, he understands that his role is to be the stable, stoic pillar in his children's lives. This requires a rejection of the Disney dad trope, the father who compensates for the divorce by being the fun, indulgent parent with no rules. Instead, case studies of successful co-parenting suggest that children thrive most when the father maintains high standards, consistent discipline, and a clear set of values. Marcus creates a new set of traditions in his home that are independent of the former marriage. Whether it is a specific Saturday morning routine or an annual hiking trip in the Poconos, these traditions provide the children with a sense of continuity and belonging that transcends the wreckage of the divorce. In this stage, Marcus also masters the art of the long game in communication. He recognizes that every interaction with his ex-spouse is still a potential legal event. Even in 2026, years after the decree, a single lapse in judgment can lead back to a courtroom. He continues to use his parenting app for all logistical coordination, maintaining a professional, business-like tone. He never speaks ill of the other parent to the children, not out of affection for his ex-spouse, but out of a strategic understanding that children eventually resent the parent who tries to alienate them from the other. By remaining the more emotionally mature party, Marcus is playing for the relationship he will have with his children when they are 30, not just when they are 10. The third pillar is the psychological recalibration. For a man in 2026, the greatest threat to his legacy is not the legal system, but the internal narrative of victimhood. The academic study of male resilience post-divorce emphasizes the need for a shift from a reactive to a proactive identity. Marcus engages in what is known as identity decoupling. He stops defining himself as a divorced man and starts defining himself by his professional achievements, his physical health, and his contributions to his community. He invests in his physical vitality, recognizing that his health is his most valuable non-liquid asset. Historical trends show that men who undergo a physical transformation post-divorce prioritizing strength training and metabolic health, experience a corresponding increase in their cognitive function and professional performance. Furthermore, Marcus reevaluates his social contract. He surrounds himself with other high-achieving men who have successfully navigated similar transitions. In 2026, the rise of specialized men's masterminds and support networks provides a framework for this social integration. These groups act as a private board of directors, offering the objective feedback that is often missing in a man's life after his domestic partnership ends. By curating a social circle that values stoicism, accountability, and legacy, Marcus prevents himself from falling into the isolation that so often leads to post-divorce stagnation. The final component of the blueprint is the legacy project. Marcus decides to use a portion of his recovered wealth to fund an educational trust for his grandchildren, or perhaps a charitable foundation focused on a cause he is passionate about. This shifts his focus from the past to a future he will never even see. This is the ultimate victory over the divorce process. When a man moves from surviving a litigation to funding a multi-generational legacy, the divorce is no longer the defining chapter of his life. It is merely the prologue to his greatest work. As we conclude this 10-part deep dive masterclass, we have covered the entire arc of the male experience in the U.S. divorce system. From the initial shock of the filing and the tactical maneuvers of the move-out trap, through the financial warfare of discovery and the high-stakes theater of the trial, to the complexities of federal tax law and the blueprint for long-term recovery. You now possess a level of intellectual and strategic clarity that is possessed by fewer than 1% of men entering the family court system in 2026. The potential outcomes for your life are no longer a mystery. They are a series of choices you are now equipped to make. You understand the historical trends, you have analyzed the case studies, and you have seen the step-by-step logic of the system. The American legal system is a machine, and while it can be cold and indifferent, it is also predictable to those who know how to read the manual. You have been given that manual. But the blueprint is only as good as the architect who executes it. The knowledge you have gained over these 10 parts is a powerful tool, but it requires the discipline of a stoic and the precision of a strategist to implement. The road ahead in 2026 and beyond will still have its challenges. There will be moments of frustration and periods of doubt, but you are no longer the man you were when this discourse began. You are informed, you are prepared, and you are dangerous to the forces that would see you decimated. This concludes our masterclass on the academic discourse of divorce for men in the USA. However, the world of legal strategy and asset protection is constantly evolving. In our next series, we will be pivoting to a new high-stakes domain that every man of means must master in the modern era. We are going to explore the burgeoning world of private jurisdictional sovereignty and the rise of the digital nomad estate plan. What happens when your assets and your family are spread across 3 different countries? How do you manage the conflicting laws of the physical and digital worlds? The next loop is about to open, and the stakes are higher than ever. Prepare for the global deep dive.